Okay. All right. Well, hey, we're gonna get started. So, good morning and thank you for attending. We're eager to continue sharing ideas about what you need to know about the SCA. So, I'm just going to give a few opening remarks, an introduction to our guest, Erin O'Shea, and then I'll pass the mic over to her, and she can dive into this important topic for all of you government contractors that are on this Zoom. So just a quick note, we are providing some ideas and resources, but not specific guidance or recommendations to you or unique business situations. Erin and I on the benefit side, I'm not going to be speaking very much on this one as I have in some past ones. We're more than happy to engage with you and your company individually as part of your advising team and our individual disciplines to provide consulting and tailored recommendations to you and your leadership team. Okay, so let's get moving. We have an hour. This webinar is approved for 1 SHRM credit and 1 HRCI credit. The certificates will be mailed to anyone that's attending post-event. Bear with me, it might actually be tomorrow morning before I send that out, but I do have them and everybody will get those reasonably timely. I am recording this, so both for those who missed it or people in your office that you may want to have see this, or if you just want to watch it again because there's a particular point that you want to review, there will be a link in the post-webinar email that will take you to that. Or if you want, you can go to YouTube and type in insurancing. Insurancing is like drop the I and then it's just insurancing, and you'll be able to find my page with webinars that I posted in the past. Please use the Q&A feature for questions that you would like answered. I think the plan for that is Erin's going to present, and then at the end, we'll do some time for Q&A. So let's just jump right in so we can finish on time at 11. So intro is just as a very quick and brief piece with me. My name is Brian Klickner, and I am with Risk Strategies. I think I'm pointing to where that is on my virtual background. Risk Strategies has over 1,800 employees and 70 offices around the U.S. We are an insurance brokerage. My area of expertise is in the employee benefits space, but we do everything from insuring your yacht, amazingly enough, to your art collection, or just your commercial needs for your business or employee benefits programs. My team, we work with clients to create bespoke employee benefits programs. So if you're interested in a kind of a different way to manage one of your top corporate expenses, we just set up a Zoom chat. So with that, I'll keep it short on my side. So Erin O'Shea. So Ms. O'Shea is assisted in the review and analysis of companies' pricing practices for government and commercial contracts. Her work has included extensive compliance reviews and quantification of the effect of the company's pricing obligations under GSA, Service Contract Act or SCA, and DBA or Davis-Bacon Act covered contracts. Her analysis have included large, complex data sets, should have been price reconciliations, back pay calculations calculations related to wage and hour requirements for SCA, extensive review of source documentation, as well as detailed review of past and current accounting practices and billing records. She has assisted in preparing schedules to document various findings for use in responding to government and DCAA, including voluntary and mandatory disclosures. And she has assisted clients in developing policies and procedures for increased government contract compliance. So with that introduction, I will pass the mic to Erin so she can lead us through this educational session. Erin?
Great. Thanks, Brian. Certainly appreciate the introduction. And thank you all for joining today from my dining room. Never thought I would say that, let alone say that as often as we have been during this. Certainly hope everyone and their families are healthy and safe through this. I want to thank you for a couple things, both for attending today as well as giving me an excuse to wear real clothes. And my boyfriend would like to thank everyone for giving me the chance to talk about this very exciting topic of Service Contract Act to someone other than him while we're in this. So with that, we'll get started. Let's see if I can share my screen here. All right, hopefully everyone can see this now. Skip over the introduction, you now know what I look like. You'll see the agenda's pretty full. And we have a lot of topics to cover. It's a very dense area. You know, kind of from the introduction Brian gave on me and my 14 years of experience. You know, I've handled a lot of different government regulations, and I honestly find the Service Contract Act and some of the other wage and hour compliance areas to be some of the more complicated. There's just a lot of gray area. So if you're involved in this world and have questions, believe me, you are not alone. Even from the consulting world, we have a lot of questions, and I feel like things are kind of always changing, or depending on who you're dealing with at well, or what your contracting officer knows or doesn't know. It's a different experience with every contract, with every company. So I want to give you the high level background, as well as some of the information on best practices for compliance, as well as the current enforcement environment and kind of what's going on with DOL and Service Contract Act. There are more slides in this deck than I know that we will be able to get to in an hour, especially with questions, but I plan on sending my deck to Brian afterwards to send to all of you. Just everything at the end is hopefully pretty straightforward, very useful information, and like Brian said, we're certainly happy to talk about any of it offline as necessary. So diving in, the Service Contract Act was codified back in 1965, which was 30 years, give or take, after the other two of the prevailing wage acts, the Davis-Bacon Act, which covers construction workers, and the Walsh-Healy Public Contracts Act, which covers manufacturing workers. I certainly won't talk about those too much, but Service Contract Act came much later. So to cover service contracts and service contract employees. The benefit of it from the government government's perspective, excuse me, it was really to protect not only itself and contractors from low bidding, but to protect the employees, the service employees, from their company potentially bidding low on a job and then getting underpaid from what certain requirements would be, but also to protect union employees from their union and their group potentially being underbid by non-unionized groups. So this kind of sets that floor in terms of wages that contractors must pay their service employees, as well as benefits. The Service Contract Act is administered by the Department of Labor's Wage and Hour Division. They are responsible for all reviews. If there are any complaints, if they don't go to the company direct, they are going to DOL, and DOL does come in and investigate. It's not necessarily on the contracting officer, though DOL will often work with the contracting officer so that everyone's aware of what's happening. SCA applies to contractors and subcontractors who have contracts in excess of $2,500 for services performed in the United States. In the United States includes Washington, D.C., and $2,500 is certainly not a big threshold, especially when you're considering what government contracts can really be awarded for. And as in most things with the government, there's some vague definitions that are in the FAR and in all the regulations that cause people to kind of scratch their head, including this principal purpose test. So it applies on contracts in excess of $2,500 when the principal purpose of the contract is for the contractor to furnish services to the government using service employees. What does principal purpose mean? I think a rule of thumb are either your FTEs or your amount of funding on the contract dedicated 50% or more to service contracts and service employees and service offerings. Is generally a good rule of thumb, but again, everyone kind of interprets that differently at DOL and in the contracting officer world. So if there are ever any questions, it is best to raise those questions with your contracting officer, especially at time of bidding, to make sure that the contracts are tagged as Service Contract Act compliant contracts, that the proper clauses and a wage determination is incorporated in the RFP for bidding, and then ultimately the contract if you are awarded it, because the Service Contract Act does not apply to your contract if it is not included in your contract. However, if a contracting officer makes a mistake and doesn't include it and it should have been, that doesn't mean that they can't go in and add it, and then your company retroactively needs to comply with the act, which, while as a company you can go back to the government for request for equitable adjustment to kind of fix the wrong that they created, it is an additional administrative burden, it's an additional compliance burden, and you kind of just have to, from an administrative side, kind of halt, not the efforts on the contract, because you don't want to be dinged for non-performance, but make sure you're getting your ducks in a row, understanding what it takes, your employees are mapped correctly, your employees are paid correctly, do this whole back kind of retroactive review if it's ever not included properly in the first place. So to that end, you know, we always encourage the more questions, the better. Contracting officers are going to answer them the way they're going to answer them. And unfortunately, they're not all as familiar with the Service Contract Act as they should be, even if the contract that they're overseeing does apply. So just make sure that you're asking those questions. If it smells funny, it probably is. Have everything in writing, so if there ever is an issue where it's coming back and being applied retroactively, you can clearly document your communication, your best faith effort to try to comply, or at least find out if you should have complied from the beginning. And I think going back to the principal purpose test, like we said, it's kind of the shaky ground. More than 50% is a good rule of thumb. But it also does not, Service Contract Act does not apply if there's incidental service work on other types of contract that would not otherwise apply to the Service Contract Act, such as the occasional service employee working on a construction contract. And you can see on this current slide kind of the inconsistency in rules here. Service employees who work on contracts which do not meet the principal purpose test are not covered by the Service Contract Act. However, on the reverse, construction employees who may happen to work on non-construction contracts, such as a service contract, Davis-Bacon Act does still apply to them. So this is, again, all of these rules are very confusing, I feel. You can read the rules and think you understand them, and then some loop is thrown. These are going to be some of those loops. So just be sure that you're always reading. If there's any questions, go back, read again, you know, or certainly engage counsel or consultants who have the experience in this if there are questions to that effect. So there are 55 examples of service contract types. We've listed just a few examples here that you kind of see more often than not of the various areas that could apply. Cafeteria and food service, I feel like we spend a lot of time supporting clients who are in the food service industry and some of the complexities there of various job duties, specific WDs, wage determinations. I'll share some of those stories along the way as I can. But you can see some of the other examples of different kind of labor types that could be considered service contract and need to have the Service Contract Act incorporated therein. There are some contract types that are exempt to SCA. Examples are contracts for construction, alteration, or repair of public buildings or public works. Manufacturing work covered by the Walsh-Healy Public Contract Act. Contracts for furnishing services by radio, telephone, telegraph, or cable companies subject to the Communications Act. Public utility services, contracts for operating U.S. Postal Service contract stations. The important caveat there is there are other jobs with the U.S. Postal Service that Service Contract Act does apply to. Example, mail haulers, all the folks driving the trucks to get our mail cross country and where it needs to be, they are all covered by the Service Contract Act. Exempt employees, bona fide executive, administrative, and professional employees as defined under the FLSA are exempt from the Service Contract Act, even if they are working on that service contract itself. They can be defined as executive, administrative, professional, are salary-based, make at least $684 a week in salary, which is an increase as of January 1st, 2010 from the $455 a week minimum. If they have managerial responsibilities, if they have the ability to hire or fire employees, if they have the ability to manage and oversee projects, and they are on that salary basis, the Service Contract Act requirements of wages, benefits, vacation, and holidays do not apply to those employees. So it's very, very critical to make sure that you are classifying your employees correct who are working on Service Contract Act contracts. Make sure you know who are exempt and who are non-exempt, and do those checks. Just, because you don't want to, from a business side, you don't want to be offering employees and paying them based on the Service Contract Act if you don't need to be. It's a lot easier if you can stick to some of your normal practices. But at the same point, you want to make sure that everyone who should be covered by the minimum wages, minimum benefits, vacation, and holiday obligations are in fact covered. Now, I want to qualify this, that this exemption applies to the wages, the benefits, the holidays, and the vacations. We will talk a little bit more about some executive orders that have gone in place over the last couple of years that are impacting federal contractor minimum wage, as well as federally paid sick leave clauses that may be incorporated into some of your Service Contract Act contracts. Those will have an impact on some of your exempt employees. But this exempt employee type is for the wages, benefits, vacation, and holiday obligations. Here are just a couple other examples of some exempt employees, teachers, and computer employees who are, again, making that minimum of $684 a week, or also if the computer employees who are performing these higher level duties are making $27.63 an hour. That $27.63 an hour mark has not changed, even though the $684 a week, as I mentioned, went up January 1st, 2020 from the $455 that it had been previously for the last number of years. So the important things with SCA, I've mentioned them, I'm sure you all are all aware of them, is that the Service Contract Act stipulates a minimum hourly wage for each job position covered under the contract, a minimum hourly health and welfare benefit, which I'll refer to as H&W a lot, minimum vacation benefits, and minimum holiday benefits. Everything that would indicate what your minimum wages, health and welfare, vacation, and holiday benefits are incorporated in a wage determination. And a wage determination needs to be incorporated into your contract for it to apply. Contractors have access to wage determinations on sam.gov, where you can get any wage determination that is incorporated into your contract. You can see the past history of some of those wage determinations. If you're on a long-standing contract that's had multiple wage determinations and for whatever reason you need to go back and check, you can always get them on the internet from sam.gov. The important thing, and one of the things that we see some of our clients do, unfortunately, is wage determinations are updated very frequently. They're updated more frequently than they're incorporated into your contract and modified into your contract with the various revisions. If there is no modification to your contract to incorporate a new revision of the wage determination, even if it is issued by DOL, it is not applicable to your contract until it is modified into your contract. So like I said, we've had clients who their customer has handed them a new wage determination and said, hey, we saw this appeared on the internet, must now apply to your contract. So they made all of the changes. The good thing is, the government will never fault you for paying your employees more and offering them more benefits than they are in fact owed. But from a business standpoint, if you prematurely incorporate or include that wage determination into your practices, you are paying more than you need to be under the law, and therefore likely reducing some of the margins that you are getting on that contract. So please make sure that they are properly modified into your contract. They need to be modified if it's an appropriated contract, it's likely every year. And if it's not appropriated, it's every 2 years. You should be receiving a new wage determination from your contracting officer through a modification. We find a lot of times contracting officers are not as up on that time schedule as the contractors themselves are. So while it is not your obligation as the contractor to request that update, we still believe and recommend that you do follow up with your contracting officer. It is in your best interest to have everything kind of, again, in line on that scheduled date, because we've seen many times where the contracting officers will modify a wage determination. Let's say they put it in as of April 1st, they modify your contract April 1st, 2020. They could put it effective back to January 1st, 2020, or any back period. At which point then, as the contractor, you need to calculate what back wages and back benefits owed to your employees would be and issue a check for that amount. So the more current you can keep the process of having the wage determinations modified into your contract, just the better, from an administrative standpoint, making sure that you're on that schedule, your employees are getting their raises, as we've often heard them call it, appropriately, and that all their wages and everything are just synced up to the schedule that contracting officers should be incorporating the wage determinations into your contract. So let's see, I think we have an example back here. We'll get to an example of a wage determination just in case you haven't seen them yet. But wage determinations are by area, and it should be the area where the work is being performed. Again, there can be some question when the contracting officer is including a wage determination, especially in the RFP, whether or not it is the appropriate wage determination. It is certainly appropriate to ask questions about that, especially during the proposal round, to make sure that you are getting the right wage determination for the right area so that your planning is consistent with what you are actually then going to be obligated to once the contract goes into play. And wage determinations often include far more labor categories than your contract is going to have. They're usually 12 to 13 page packets with every single labor category listed. So it's important that you identify which labor categories apply to your contract, so that you know which wages are then going to apply to your employees. Wage determinations can be odd or even, and we'll talk about the difference between the two of those in a little bit, but just know even numbered wage determinations are being phased out. They are only being used right now, or should only be used right now, in grandfathered contracts that previously had an even number wage determination. And the difference between the odd and the even is simply in what the contractor's obligations for benefits is and what the test is to make sure that the contractor is in fact paying the benefits at the right rate, as well as when health and welfare, how many hours health and welfare needs to be paid on. There are some non-standard WDs. These are usually for very specific industries. Like I mentioned earlier, we have a lot of contractors who are in the food service industry. So they have some that are full kind of cafeteria restaurants, where they use a standard wage determination, and it has cook 1, cook 2, cashier, food service worker, those sorts of typical food service work categorizations. And then they have some locations where they have a fast food wage determination, which really is just 2 levels. And within that, it has 2 levels. It has the 2 wage rates, but the application of vacation and holiday is very different than a standard WD in this specific instance. We'll see in a second the standard WD, how it lists out your holiday and your vacation obligations. It's in full days, it's in weeks. On the fast food wage determination, it's a certain dollar amount that you owe per hour worked, rather than actually obligating you to issue that employee a certain number of days of vacation or holiday. It just becomes additional pay. And collective bargaining agreements, if it is a unionized group, the collective bargaining agreement, if it does exist with your workforce, trumps the Service Contract Act wage determination that would be incorporated into your contract. The contracting officer will issue, there will be a different wage determination that kind of gets modified into your contract, but it's very specific to that collective bargaining agreement. So I teased a little bit about the differences of odd-numbered and even-numbered WDs. Even-numbered, like I said, again, they're being phased out because there's no reason to have two different ways to do this and further complicate it. It's an even WD if the last number of the wage determination is even. Odd if it's odd, as in the examples here, 4281 would be an odd number wage determination. And again, the only difference is the health and welfare application. In an odd number, contractors are obligated to pay health and welfare on up to a maximum of 40 hours per work week. So it's either the less of the number of hours worked by the employee, or 40 if they happen to work more than 40 hours that week. That is the amount of hours that you need to apply the health and welfare rate to calculate how much health and welfare or benefits are owed to your employees. And it's calculated on a per person basis. So if I work 40 hours, I'm gonna get my 40 hours of health and welfare. If Brian works 20, he's gonna get 20 hours of health and welfare. The reverse is in the even numbered WDs, you look at an average health and welfare across all of your service contract employees, and that is changing on a weekly basis. So you wouldn't necessarily owe me 40 hours and owe Brian 20 hours. If we're the only two employees, you would owe us each 30 hours of health and welfare to be compliant. Now, you can certainly pay me 40, pay him the 20 hours of health and welfare, and when you're doing the calculations, it's fine. But if in any case, you know, you're not doing it in the per hour basis for employee, the check is to make sure that at least on an average basis, your employees have received all their hours for health and welfare. And the health and welfare hours, it's applied to all hours worked on the contract, including overtime. But in this case, you're not paying health and welfare on vacation or holiday hours since they were not worked. And that reminds me that I didn't mention that in the odd number. It's up to a maximum of 40 hours of paid hours a week. So if you take vacation or holiday under the odd number WD, the contractor still needs to pay you on those hours, the health and welfare, up to 40 hours a week. Here is an example of a wage determination. You can see at the top here, it talks about Executive Order 13658, which is the federal contractor minimum wage. This changes every year. So you can see right now, as of January 1st, 2020, the federal contractor minimum wage is $10.80 per hour. This section only applies to your contract if you have this executive order and this clause is incorporated into your contract. If this clause is not in your contract, you can ignore that top paragraph. And it is very important to point out, while this example does not show it, there are some cases where despite DOL updating that top paragraph to cover the minimum wage, they do not always cover the wage rates incorporated in the wage determination pages up to that wage. So for example, again, back to the food service, there are certain cashiers or dishwashers where the wage rate may be listed at $9.50. if you have the executive order for the federal contractor minimum wage, despite the fact that that wage rate is listed at $9.50, you owe a minimum of $10.80 per hour for that employee. And that wage rate increases every year. And as long as that applies to your contract, you are obligated to increase that minimum every year. And then this is many pages into the wage determination, usually at the very end of all of the labor categories, where it'll talk about your federal paid sick leave, which again, if that clause is included in your contract, you are obligated for it. If it is not, you can ignore that paragraph. We'll talk more about that later on in this presentation. And then it lists your health and welfare hourly obligation. Ever since the paid sick leave clause went in, wage determination are now including 2 health and welfare rates. One applies if you are not obligated to the paid sick leave. One applies if you are. And again, those are the benefits that you owe. We'll talk a little bit about how you can cover that. And then at the bottom, we also list the number of vacations that employees are eligible for and need to be paid for, as well as holidays. An important thing to note about vacation, and often where some contractors get tripped up, if you have an employee, say an incumbent employee that you are bringing on as one of your workers, they get their full service. So it's not just their time with you, it's also their time on that similar contract with prior contractors, their consistent time. So even if they've only been with you a year, but they were with the incumbent contractor for 5, they would be eligible for more vacation hours. So it's always important to know how long and what the seniority of your employees are. And if they have that successor component that would make them eligible for more vacation than they otherwise would. It's also important to note that under the Service Contract Act, vacation is based on an employee service year, not necessarily a fiscal year, not necessarily a calendar year. If you have a lot of employees, this gets very complicated because every single employee has a different point where their vacation is going to turn over, or if they hadn't been paid out for any of the vacation that they vested or that they accrued, that you as the contractor need to pay out your employee those remaining hours on their anniversary date. So that becomes a bit of an administrative headache we see for a lot of our clients, you know, with many calendar reminders and checks to make sure that they're checking every employee and checking those service dates pretty regularly to make sure they're never falling out of compliance based on the employee service anniversary. Since again, it's not one date for all of your service employees. This is kind of what we were talking about before about how you can access the wage determinations and how it's the contracting officer's obligation to incorporate the wage determination into your contract. Again, just to reiterate, if they don't incorporate an update or a revision to your contract, you are not obligated to pay that new version. Okay, so wages. All the wage determinations have the minimum wage rate per hour for your service covered employees. And to make sure that you're meeting that obligation, that could come under salary, piecework payments, any bonuses that you pay to that employee, or any combination thereof to meet that minimum wage rate. It is very important to keep your wages and your benefits separate. If you pay additional wages above what is obligated under the Service Contract Act, you cannot use those additional wages to offset the benefit obligation that you have, or vice versa. And the amount of wages paid to your employees, as well as the benefits, needs to be reported separately on their pay stub. The wage determination, again, it's going to list all of the wage rates. It's very important that you regularly review the Service Contract Act Directory of Occupations, which is available on the DOL website. This lists all of the job duties that apply to each of those job categories and job category codes. I think an important example here, again, I'm going to pick on the food service, and one of those is one of our clients has SCA covered cafeteria work and commercial cafeteria work. They have internal codes of Cook 1 and Cook 2. Service Contract Act also has job categories of Cook 1 and Cook 2. The way they define Cook 1 and Cook 2 internally is a more senior cook is a Cook 2, earns a higher wage. Less experienced kind of sous chef is a Cook 1 and earns a lower wage. If you look at the Directory of Occupations, that is not a consistent classification. For the DOL, Cook 2 are higher quantity foods and more complex cooking techniques, whereas a Cook 1 is smaller quantities, simpler techniques. So just there's some inconsistencies with the internal classifications, the DOL classifications, and maybe even what a prudent person would assume the difference between a Cook 1 and a Cook 2 is. That is why it is essential to understand and correctly map employees to the SCA labor category under which the duties they perform fall, rather than just where you think the clearest labor category name description is, or where you think the job duties should fall based on labor category names. Very, very important to check that. It's also important that if an employee is ever working kind of in multiple lanes, they're doing multiple duties, like food service industry, again, we'll say someone who cooks in the morning and cashiers at night. The Cook 1 rate, if they are a Cook 1, is much higher than a cashier. Typically, the contractor can either pay all of their hours under that higher rate to be in compliance, but what you as a contractor can do is mandate that the employee records their time different, and they really should, even if you're paying them at that higher rate, record the time they're working as a cashier, record the time they're cooking and being a Cook 1. You can also pay them at the different hourly rates for the hours they work under those job duties. It's a great practice when it is very easily controlled, when employees are good about entering their time differently, clocking in, clocking out under different codes. Human nature is often hard to do that, or if some employees are deciding, hey, let me go help my friends and I'll just fill in as a fill in the blank for a little bit to give them a break or whatever, you as the contractor are required to pay the employee for those hours worked. Even if they don't record it, you should have known they can call in a complaint to the Department of Labor that, hey, I worked at a much higher labor rate and I didn't get that payment. So it's very important to try to keep your employees in the lane that you want to set for them. Certainly if you want to set that they have multiple responsibilities, record their time on multiple categories and get paid under multiple rates, that's fine. And if you don't, make sure that you have those conversations again and again and those reminders, that employees are obligated to do their job, which will help on the back end and hopefully on the compliance side of making sure you're paying them for all the hours they worked under the job category that you are anticipating the work from. And in terms of record keeping, the employer is required to maintain all records of hours worked, make sure that they are paying under all those obligations. The fringe benefits, this is the health and welfare. It can be paid out a couple different ways. Some contractors choose to pay benefits cash in lieu of benefits, meaning they don't offer traditional benefits to their employee, but the employee gets an additional health and welfare or benefits line on their pay stub with additional payment in the amount of that health and welfare rate times the number of hours that they are eligible to receive that health and welfare per pay period. That's one way. employees like it a lot because they feel like it's extra cash in their pocket. While they may think that their wage rate is their regular wage plus their health and welfare rate combined, it is crucial that as the contractor, you separate those two if you are paying in cash. On the pay stub, the wages and the benefits must be reported separately. I also want to reiterate that additional wages cannot be used to offset any health and welfare obligations or vice versa. Which is different. Again, Davis-Bacon, we're going to talk about inconsistent rules. Davis-Bacon is the construction kind of act. They can use higher wages and or benefits to offset the reverse. So service contract world, you cannot offset. I'm sorry. And the other way you can pay the fringe, the health and welfare, is through traditional benefits, either through a third-party administrator, or if you have a self-insured benefits plan, which if you have a self-insured benefits plan, it needs to be approved by DOL. Any service fees associated with that third-party insurance provider, administrator, they can come from the employee's health and welfare contributions and offset that way. So that's often very appealing to contractors, that they're not paying that administrator fee. It's coming out of what they are already obligated to pay their employees anyway. Even though you have, in those cases, a third-party administrator kind of helping you with the whole process, it is still the contractor's obligation to ensure that employees are getting the benefits that correspond with the health and welfare that they are owed. So just make sure that you're reviewing those reports, making sure that the TPAs get the updated wage determinations, and that everything is in line there. Kind of just reiterating what we said. Okay, and then vacation and holiday. We walk through on the wage determination where you find what vacation and holidays are owed. Vacation, again, remember that it's any time with your employee, with you as the contractor, as well as any time with a predecessor contractor, if it is for the same duty in the same location, and that it's based on the employee's anniversary date. Holidays are mandated as well by the wage determination. Employees are usually either eligible for 10 or 11 holidays, depending on what the wage determination says. And it's a very standard list of holidays. It's pretty much the federal holidays. If it's 11, you add in Good Friday. Employers do not need to necessarily give the employees those specific holidays off in order to qualify, as long as you are still providing your employees with the right number of holiday hours that they're eligible for, even if it falls on a different day, or, you know, again, you as mail haulers, they have to haul the mail no matter if it's a holiday or not, no matter if the post office is open or not. A lot of times they're working through the holidays. So then they would get their regular pay plus their holiday pay. And it is important, if you are a full-time employee, you get 8 hours for every holiday. If you are a part-time employee, it depends on if you are regularly scheduled, i.e. you always have, let's say, 24 hours a week that you are working regularly, no matter what the schedule is. Or if you are irregularly scheduled, 16 hours one week, 24 hours another week. If you are a regularly scheduled part-time employee, the employee is owed a prorated amount of the holiday, of the 8 hours, based on the proration of the number of hours they are regularly scheduled for in a week over 40. If you're an irregularly scheduled employee, you look to the week before to see how many hours did they work the week before the holiday. The prorated amount of that week over 40 is the same amount that gets applied to the 8 hours of holiday to determine their obligation. And employees are eligible for holidays the day they start working. So if you start working on July 3rd, you are eligible for some portion of the July 4th holiday. Record keeping is very important, as in all things government contracts. Almost excessive record keeping is good, more than you think is necessary. You are required to keep records for 3 years, which includes all of your roster information, all of your employee information, as well as what labor categories are you paying them at, what wage rates, fringe rates, how many hours did they work, how many vacation hours did they take, how many vacation hours did they get paid for, etc. Very essential that you keep all these records, especially if there ever is a DOL complaint or an internal audit, that you have the records to go back to. It's certainly much easier to look at history when history exists rather than recreate history. Unfortunately, that's not always the case. It's easier to remember that once there is an issue sometimes, but you are obligated to keep everything for a period of 3 years. Another thing that's kind of a low-hanging fruit and is often missed, but is one of the first things DOL will look at if they ever come to a site visit, is posters. As a contractor, you are obligated to have your employee posters up either in a public space, maybe near a time clock where they can regularly see them, or there's some contracts where employees are not in a central location. Therefore, putting them on some kind of intranet site or something that the employees have access to. There is a Service Contract Act poster that needs to be hung, and there is a box that says Service Contract Act or Davis-Bacon. You need to check the one that applies. If there is no check, even though the poster is posted, DOL could ding you. If federal paid sick leave or federal contractor minimum wage is applicable to your contracts, there are also posters that need to be hung to that effect. And in addition, the current wage determination needs to be posted. Some contractors don't like to do this because it gives employees an idea of what their colleagues are making in different roles. Sometimes leads to employees saying, hey, I'm a cashier, but I see cooks make a lot more. I can fry an egg, please let me in. But you're obligated to post it and make it available. If you happen to have multiple wage determinations, again, I'm going to pick on mail haulers. Sometimes you have truck drivers coming from multiple locations and running different contract routes, so therefore different wage determinations apply to them. You need to have all possible wage determinations available to your employees who are working on those contracts. There are price adjustments clauses that should be incorporated into your contracts so that if a wage determination, again, every year, if it's an appropriated contract, every 2 years, if it's a non-appropriated contract, when those increases come in so that you can adjust the price of your contract to be compensated for that increase, as long as there is not escalation already in your bid. Any of those adjustments does not cover changes to your overhead, G&A, or profit, or anything like that. It does cover if there is a conformance. We're going to kind of breeze by conformance, especially given our time, but a conformance is basically if you have an employee performing a wage duty, job duty that does not exactly align to one of the wage determination job categories or can't be assigned to multiple. For example, if you happen to have an executive chef who's a service contract employee but does more than a cook 2 would and who's supervising all of your cooks, you may need to conform for a cook senior or a cook 3, which does not currently exist in the wage determinations or the Directory of Occupations. And that is a process that you work through with your contracting officer and DOL. And the idea there is just to make sure that every employee has a job category and has an agreed upon wage rate and benefit amount tagged to their job that the contractor can be held to. All right. SCA compliance challenges. There are many. SCA is very complicated. It is, like I said, every time you think you get it, something else kind of sneaks in there. We saw a very interesting statistic that a couple of years ago of everyone who was audited, 78% of those audited by DOL were found to be non-compliant. My guess is realistically, if they looked a little deeper, they would have found that number to actually be higher than 78%. You're always going to find a problem. The question is, how major is it? But some of the common pitfalls, not realizing that SCA does actually apply, or to what employees SCA applies. Failure to recognize which laws apply, whether federal contractor minimum wage applies to you, federal paid sick leave, any of those, whether or not there's the wage determination updates, or whether or not a wage determination was ever incorporated into your contract. Again, that's the contracting officer's responsibility. As long as it's not incorporated, you are not obligated to pay the wage determination rates, but it could come with that administrative burden when it is correctly retroactively applied. You could still wind up owing the money associated with that. Benefits, making sure that you're paying the employee the right benefits, that you're correctly addressing health and welfare through bona fide benefits, which again is either the cash in lieu, traditional benefits through the self-insured plan, or the third-party administrator. You could also use additional vacation or holidays that you give to your employees above what is obligated on the Service Contract Act as a benefit offset. Or jury duty in most states is not required to be paid. It is not an SCA obligation. If you pay your employees for any time they take for jury duty, bereavement, other such benefits such as that, that can be used to count towards your health and welfare obligation. Really, I think also the biggest thing is making sure that your employees are correctly mapped to the labor category, that they're correctly recording time to those labor categories, and that you're paying them based on the late labor rates. Vacation, like we said, there's usually a vacation ding, especially with the fact that employees are each on their own anniversary year. And if they're coming from an incumbent contractor, their number of service years is higher than you may have recorded in your roster. So if you are found of a non-compliance, it really depends on how big it is, if you're a first-time offender, who your DOL representative from Wage and Hour is, how they're feeling that day, as much as I hate to say that. And some of the pitfalls and the consequences that could come are you owe back wages, which is just calculating how much you should have paid that employee minus what you did pay them and paying them the delta. That process, if it's overseen by DOL and Wage and Hour, goes through DOL and Wage and Hour, and there are forms, and they'll review your calculations and they'll sign off on things. There could be civil penalties, contract withhold, debarment, suspension, which certainly is not what you want to hear, or not what you want to go through. Contract terminations and the repayment of government's procurement costs. All sorts of things that you certainly don't want to get involved in. So having very strict compliance policies and procedures, reviews is quintessential. And I think one of the very, very important things with Service Contract Act, among many things, is it's not just one person or one division within your company that is responsible for this. Service Contract Act kind of affects every division, right? It's an HR issue. It's a project management issue, it's a finance and accounting issue, it's a contracts procurement issue. If you're in procurement and you have subcontractors, you have to make sure that you are correctly flowing down all of the Service Contract Act clauses, the wage determination, and all of that, your subs' obligations. It's a matter of determining how much you want to help your subs be compliant and ensure compliance, because at the end of the day, if you are the prime, you are responsible for that contract. So it really spans everyone, and it's making sure that folks who are making business decisions understand what the impact of the Service Contract Act is on that contract and on all of those various business functions. Some of the best practices are, be responsive. DOL asks you a question, your employees ask you a question, answer them. Especially if employees are coming to you with compliance questions, it's best to answer them because you don't want them going to DOL and you don't want a DOL investigation started. At the same point, you can never block your employees from going to DOL. And once they do, DOL could come in. Just because DOL comes in does not mean there is in fact an issue. It may just be a disgruntled employee. It may be an employee who doesn't quite understand the Service Contract Act. which is very understandable. It could be an employee who saw that their buddy made more money than them and they didn't understand why. DOL is going to look at the facts and the issues to determine if you owe any money. But again, so it's important to be responsive. It's important to educate DOL on what your practice is, what your business is, how you ensure compliance. So let them know. Every company that they're going into is different. Every company handles it differently. Tell them what the story is. Answer their questions. Make sure you are doing an independent review so you are not surprised by anything. And if you do find an issue, own up to it. I find it's always best to say, hey, we found this issue. We're looking into it. We want to correct it. We are here for the federal government. We want to be in compliance. It's our highest priority. DOL is going to take usually pretty kindly to that, especially if it's a first-time offense, and work with you to help you fix it. Because a lot of times if these contracts go away, service to the government is disrupted. Train your personnel. Again, that covers all various business functions that we listed earlier. Having internal controls to make sure that you're covering the compliance, clearly communicating job responsibilities to your employees and what lane they should be staying in, your records, subcontractors, et cetera, et cetera. You know, understand when there's a new WD, what the process is to get the request for equitable adjustment, if it's applicable. Perform regular self-assessments. Again, you don't want to be surprised by an issue if you can avoid it. Resolve compliance issues quickly, both with employees as well as DOL. Advocate for your company, manage the communication. You want your employees to know that you're taking this seriously, that you're looking into anything, that you're trying to ensure that they are getting the wages and benefits that they're obligated to. And if you ever have any questions, it's complicated. That's why there's outside counsel. That's why there's consultants who focus on this. So it looks like we have about 4 minutes. I don't know if there's plenty more to talk to, but I certainly want to give some time for questions.
Yeah, thanks, Erin. I appreciate it. So we do have actually, there is a question, and I've got a couple as well to see the conversation. So anyone that has any questions, please put them into the Q&A feature. But I'll start off with this one that came in. So, and I think it goes back to performing self-assessments. So the question is, if we wanted to do a SCA sweep or internal audit or perform a self-assessment of our contracts to determine what applies and what doesn't, who would be the best person to assist, the best outside person is what I think the question is gearing towards. And it says, and the question is like, is a labor and employment attorney or who?
Yeah, I think that's a great question. And I certainly think it depends, which I know is not the answer you want to hear, but there are some great labor and employment attorneys out there who focus on this, who can help review your contracts to figure out what applies where, and then help you then review the policies and procedures. Oftentimes, consulting companies such as BDO, but there's many others in addition to BDO who perform this kind of work hand in hand with attorneys to do this. A lot of that is they may specialize in the contracts and the legal side of things, whereas we can dive into the numbers side, do the employee interviews, go on site and kind of take the temperature of what's happening. You know, and so I think it's a really good relationship depending on what the scope of your contract review is. Maybe you start with counsel and then you bring in consultants depending on what areas you think may be a little fuzzy and need a deeper sweep. Even if it's having the consultants guide your own employees of how to do it, since we've been through the process so many times, you know where to look, where to start. It doesn't mean we need to be the ones to do it. We could oversee it. We could tips and tricks, that sort of thing. But I would say probably 70% of the time it's a joint effort between counsel and outside consultants. But certainly nothing wrong with starting with one or the other and seeing how far you need to spread from there.
Good, thank you. Next question is for even WDs. Do you have to average the health and welfare hours every pay period?
Yes.
Right,
yes.
good.
Which technically yes. I'm sure some companies, as they're doing it, probably don't always do it every period, but to be fully compliant, yes, you do.
Thank you. I see. Can you talk about the recent changes to SCA positions as it relates to the new contract award and requirements for offering the incumbent staff members their positions?
Yeah, so great question. I'm going to jump ahead a couple slides because we actually have that. Back in October 31st, 2019, President Trump revoked hiring incumbent workforce executive order, which was the non-displacement of qualified workers. Basically, it was the right of first refusal, so that if you took on an incumbent contract, you had to offer incumbent contractors the job first before you filling it with your own folks or putting out job postings. That was revoked. The day that was revoked, it goes away from all RFPs, all contracts, anything like that. So I think it's a good thing from a contractor's perspective. It gives you the opportunity now to work with your workforce, to define and shape your workforce the way you want to, rather than pulling in incumbent workforce if that's not part of your plan. That being said, we still have a lot of clients who are relying on the incumbent workforce and hiring them simply because they have some of the background knowledge and the relationships. But it's great that it can now be a business decision by what to do rather than mandated by the executive order.
Good. Thank you. All right, so we have time for one more question, as it is 11 on the dot now. So I'll ask this and then I'll just do some quick closing remarks. So the last question is, at the end of a contract, would the incumbent contractor have to pay out accrued PTO prior to the new contractor assuming the work?
Yes, they do.
Perfect. Good. Well, I had a couple of kind of seed questions, but it looks like we had some good engagement from the audience, so thank you for that. Just in closing, I'll email the CE search tomorrow, and Erin had indicated that she would send me this deck, so I'll include that deck and copy her on that email, so you'll have her contact information if you needed to reach out to her individually. As you exit the webinar, there is a short survey, so it takes less than a minute. If you wouldn't mind completing that, I'd appreciate it. Lastly, I'll be hosting a webinar next week titled Virginia's Employment Laws Have Radically Changed. There'll be a link in the post event follow-up. And then the following week, I'm hosting one on workplace diversity inclusion and inclusion, excuse me. And then kind of additionally on the webinar front, I think the summer is going to be a little different than what we're used to. So I have a couple of web series coming up. One on kind of the employee life cycle, which is a 3-parter, and one on security clearances, which I anticipate to be a 2-parter. So with that, I thank you all for your attendance and engagement. And Erin, I really appreciate your engagement and your expertise. So thank you for sharing that with us today. And everyone, have a great rest of your day. And, you know, we're at Memorial Day. So amazingly enough, I didn't know Memorial Day happened in March, but it did this year. So thanks so much, and have a great day.
Thanks, everyone.